and he finally did it. So the prosecutor took that statement out of context. He violated the law. No surprise, but he did it. And to this day, the courts of the United States have allowed that misquoted, taken out of context statement to show Mumia's character that he's a violent person. When Mumia's case went before the Pennsylvania Supreme Court and they issued a ruling in March of 1989, they said it was okay for the prosecutor to do that because that showed character. That he was portrayed during the trial by Sonia Sanchez, she left, as a peaceful person, so we should show that because he believed that political power comes from the barrel of a gun, that he was a violent person. Well, they took it out of context, but this is the way they roll. They come up with anything that they want, and then they throw it on you, and that's supposed to be legal, lawful, fair, and just. That's one of the themes in Mumia's book, that judges just do whatever the heck they want. And that's wrong, fundamentally wrong. It's wrong in Mumia's case, it's wrong in Troy Davis's case, it's wrong in Linda Peltier's case. We could go down the whole list. It's just wrong. But let me tell you how these weasels on the Pennsylvania Supreme Court kicked it off to the weasels on the US Supreme Court. In 1989, the Pennsylvania Supreme Court said it was all right to use Mumia's Black Panther Party membership against him. They appealed to the US Supreme Court in 1990. They said, whoop, we don't want to hear your case. And we don't even have to tell you why we don't want to hear your case. Get back, stay in jail, do not pass go, no $200, death row for you, boy. Black Panther boy. A year later, there was a case that came out of Delaware. It was a guy named David Dawson. He was a member of the Aryan Brotherhood, a white racist prison gang. He escaped from prison, and while he was on escape, he killed a woman. During his trial, they said that he was a member of the Aryan Brotherhood, and he appealed it. He said, that's wrong. You can't take my First Amendment rights of association and use that against me. The Delaware Supreme Court cited only one case to reject his point on that, and that was Commonwealth versus Abu-Jamal. They couldn't find no cases in the Supreme Court, no cases in Delaware, no cases nowhere but Mumia Abu-Jamal. So the white racist appeals to the US Supreme Court, and guess what? Do I have to say it? They granted him relief. They said it was wrong to use his association against him. So sitting in death row up in Huntington, Mumia says, wow. Now, if the US Supreme Court eliminated David Dawson's case, and his case was bested on my case, then my case is thrown out. That's logical, right? You don't have to go to law school. You don't have to know mathematics. I mean, this is like 1 + 1 = 2. This ain't no new math. You don't need no calculator. This is logical. Well, logic and law don't apply in the Mumia case. So Mumia applies to the Supreme Court again. He writes his own brief, jailhouse lawyer. What you did with Dawson should free me. And what did they do? Get back, boy. We're not going to do anything for you. Now, if that wasn't bad enough, a year later, a case comes out of Nevada. A guy named Dale Edward Flanagan. Dale Edward Flanagan killed his grandparents for the insurance money, and after he kills them, they take part in a devil-worshiping ritual. So Flanagan appeals his case to the US Supreme Court, and the US Supreme Court says that in Dawson, when we gave the white racist prison gang member relief, we're going to give Flanagan relief. In 1998, the Pennsylvania Supreme Court again upheld Mumia's conviction. And they said, wait a minute, there's this business about the Dawson ruling. And they were so indignant, they said, it is outrageous that you would bring this up to us, because we've already ruled on it. Get back. In that ruling in 1998, the Pennsylvania Supreme Court said that Sabo, the guy who was a racist and a bigot at the trial in 1982, a guy who in the 1995 appeal hearing was so bad, he was so biased that even the Inquirer and the Daily News, the two papers in this city who hate Mumia's guts, wrote editorials criticizing Sabo and criticizing the Pennsylvania Supreme Court for not removing Sabo. During that time period of that 95 appeal hearing, over 300 articles was written about this, many of them criticizing Sabo. The Washington Times, that law and order, conservative, right-wing paper, had a headline saying, "The hanging judge at work." So when it gets up to the Pennsylvania Supreme Court, what did they say? Oh, the opinions of a handful of journalists don't convince us that Sabo was biased. If I wasn't in the church, I would describe it in a way that has two letters in it. One is B, and I'll let you use your imagination for the other letter. Another interesting thing happened in that 1998 ruling. One of the members of the Supreme Court was a dude named, or is a dude named, Ronald Castile. Now, Ronald Castile was the district attorney of Philadelphia. And the issue was, since you were the district attorney, you can't be fair in this case because you have fought to keep this man on death row. Now, that is a logical argument, right? If you exhibited a fixed opinion on one sense, you can't be fair on another. But there's another little legal thing here. There's a thing called the Judicial Code of Conduct. These are the rules that all judges are supposed to follow. And there's a section in this Judicial Code of Conduct that says that if a lawyer who worked for a government agency and knows facts about a case becomes a judge, he got to get off the case. So Castile wrote a 10 or 12-page opinion, said that I'm not getting off this case, I can be fair. And the defendant accuses me of bias because I've taken money from the FOP, the group that wants Mumia executed. But it's unfair to criticize me for taking money because 5 other members of this court took money too. And he named their names. So we have 6 members of a 7-member court taking money from the FOP and making a unanimous ruling against Abu-Jamal. Is that fair, or is that judicial misconduct? That's judicial misconduct. So when you hear the Michael Smirkanishes of the world, when you hear these other idiots saying that Mumia had a fair trial, you can call it, well, not in this church, but after you get outside, you can call it what it is. Because it ain't fair, and it ain't just. I just want to say few things, and then I'm going to leave out. The evidence. We hear so much about the evidence. We have conclusive evidence against Mumia Abu-Jamal, and a jury of his peers has convicted him. Well, the reality is, the evidence that we know today, the jury never heard. They never heard it because the prosecution and the police withheld it. They never heard it because his attorney never presented it right. And much of it they didn't hear because Sabo said, you can't say this.